So thank you, Professor Roy, for writing this book. I have to confess that I came at it from the very blinkered perspective of a constitutional lawyer, because I was reading the book and I kept thinking, what argument from here can I use in the ongoing challenge to the CAA? Would this help? Would that help? And there's a lot that helped, and I'll try and talk about some of that. And interestingly, my first point actually, in a sense, carries on from something Arudra said, because when you look at the constitutional text, and this is something many people have pointed out, the actual provisions on citizenship are quite thin. So Article 5 onwards, you have a set of very specific provisions that are discussed in the book that very clearly are designed to tackle the situation of partition and what to do with the migration of populations during partition, which is a little odd because the Constitution is normally meant to lay down principles that will endure and not specific solutions for concrete problems. And that's one of the many ways in which the Indian Constitution is a unique document. So you have from Articles 5 to 11 a set of provisions that deal with very concrete mechanisms to solve issues of partition. And then you have Article 11 that says that nothing in these foregoing provisions will prevent the Parliament from making citizenship laws. So the idea was that once we have settled this big issue with respect to the partition, we can then move on and Parliament can then decide what the citizenship law will be for the country. And Parliament did. And one of a broad point that the book makes is that the initial regime that Parliament put in place has altered over time in two ways. One, there has been a shift from a more universal idea of citizenship that turns upon the fact that everyone who is born in the territory ipso facto becomes a citizen of the territory. So it's you're bound by birth by being in that space, towards a more ethnic idea of citizenship that traces your right to belong through ethnicity, descent, and so on. And that's been a shift that has come in over time through various amendments that the book traces out, and the 2003 amendment being a specific inflection point. And the other way in which this changes sort of a horizontal splitting, creating different regimes across the country, and of course, specifically in the case of Assam, a very different regime that is quite separate from the rest of the country, and that's something the book deals with. So that's the change. Now, the problem, of course, is that given that you've had all these changes, given that these conceptions have altered even radically over time, on what basis, or at least on what constitutional basis, do you oppose something like the CAA? Because if historically it was always the prerogative of the Parliament to decide what citizenship would look like in the country, and given that historically Parliament has always done so, then what is so different now? And I think that the valuable argument that the book makes is that it shows us that a close reading of the Constituent Assembly debates demonstrates that while the idea was that Parliament would decide the specifics of citizenship laws, there was always a broader principled framework within which Parliament was meant to act. So the framers of the Constitution did lay down a set of broad principles that would govern constitution making, amendment, and legislation in general, that would place the outer bounds upon what a citizenship law could seek to accomplish. And those bounds are to be determined by looking at the debates as well as the constitutional text as a whole. So of course the debates are always controversial. The Constituent Assembly is what we call a polyvocal body. It had many members with differing views, and the book really brings out those differences. But ultimately what matters is how these differences were resolved in the form of a final constitutional text. And so when you read that final constitutional text, the argument is that what prevails ultimately is a kind of universalistic vision of Indian citizenship, which flows not from the provisions of citizenship themselves, because as we've seen, those are very concrete and they don't mention the principal basis of citizenship, but these principles flow from the Constitution when read as a whole. So if you look at part 3 of the Constitution, the Fundamental Rights chapter, the very basic premise that there shall be equality before law, and every person, not just every citizen, but every person shall be treated as an equal before law. That, for instance, shows you that a citizenship regime, which is obviously a legal regime, has to conform to certain basic principles of equal treatment, regardless of caste, sex, religion, and so on, which of course is in the next article, which is narrower. You have the constitutional preamble that is framed in universal terms, and so on. And so, therefore, if you nest the citizenship provisions within a broader constitutional vision of equality, universalism, and so on, while you can have different concrete articulations of citizenship laws, certain types of articulations are ruled out because they violate the overall constitutional framework. In specific constitutional language, we call this implied limitations. So the idea is that there might not be an express prohibition upon a religious or religion-based citizenship law in the Constitution. So you can't point to a specific constitutional provision that says that the state shall make no law that confers or accelerates citizenship on the basis of religion, which is of course what the CAA does. But what you do say is that the overarching constitutional principles of equality, secularism, and universality place certain implied limitations on what Parliament can do. So even if it's not in the text, it's present in the Constitution structure. The basic structure doctrine, which I'm sure you all know of, is actually ultimately comes from a similar idea. Although there is controversy over whether the Supreme Court accepted the principle, but if you think about it, the idea is that there are certain basic features that act as an implied check upon how Parliament can amend the Constitution. So the first point I want to make is that I think that the book makes this, and it complements the work of lawyers by making the historical argument that a reading of the Constituent Assembly debates shows us that there were always meant to be certain implicit constraints in the document's text and structure that would prevent sectarian laws. You could have other kinds of citizenship laws. You could, change, alter, and that's happened. But what you can't have is a sectarian law, and that's something that is something basic. That's the first point, and I'll come back to it at the very end when I talk about the protests against the CAA. The second point, and this is something that I have found is not talked about enough, and I'm glad that the book raises this point, is the Supreme Court judgment in Sarbananda Sonowal's case, 2005. That really, so the book talks about how 2003, the amendment sort of created these two paths that ended in the NRC on the one hand and the CAA on the other. But if the 2003 amendment created those paths, the Supreme Court's judgment in Sarbananda Sonowal basically sent the train racing down those paths with great speed. Because what happened in that case was that there were various issues. But one issue was that, so Parliament had made a law, the IMDT Act, that had basically sought to loosen the stringency of citizenship laws. And one crucial part of that law was that under the pre-existing regime, if say the border security force got hold of you and took you to a foreigners tribunal and you had to become part of those proceedings, the burden of showing that you are a citizen was upon you, on the presumed logic that you as the person would have the documents in your possession that would show that you are a citizen. The state wouldn't have those documents. The state could not prove the negative, and so it would be up to you to show that you are a citizen, and you would have access to all the material you needed to show that. Of course, as we all know, that's not how it works in practice. And it's direct, and the access to documentary evidence directly tracks socioeconomic status, all of that, gender as well. So Parliament in the IMDT Act moved away from that idea and reversed the burden. So Parliament said that actually the burden lies upon the state to show that you are not a citizen. And that was a very, very important shift, and that, along with a number of other issues, was challenged in this case. And in this case, the Supreme Court does something unheard of in the canons of both Indian and global constitutional jurisprudence. Because, and I'm sure that you will have noticed this, whenever a case comes up in which the state makes an argument of national security or security of the state, the court always defers and takes a hands-off approach. Most often this comes about in the context of civil rights cases, internet shutdowns, specifically in Kashmir, other places, and so on. And the Supreme Court, the government state says that, look, we know the facts on the ground, we know that there is a problem, we know that we need severe measures to deal with the problem. You, the court, doesn't have access to the facts, so don't interfere. And the court always says, we won't interfere. And that's something which is not just this court, but courts across the world. In Sarvananda Sonowal, bizarrely, the Supreme Court says that you, the Parliament, don't know enough about the national security situation. And so we, the Supreme Court, know better. We say that there is so much migration happening in the border areas that it actually amounts to an external aggression. And under the Constitution, you, the state, are meant to protect citizens from external aggression, and your liberalized law isn't doing that. And so we, the court, will say that you, the Parliament, cannot pass a citizenship law that liberalizes the regime, and so you have to go back to the old law, which is that the burden of proof rests upon the individual who is accused of being a non-citizen. And that's actually extraordinary, because this is exactly the situation where, in every other case, where you go and say, my rights are being violated, and the state says that, well, yes, too bad, but things are bad, and we, the state, know how to deal with it. The court always says that, we can't step in when there's national security. Whereas here, the court is saying that the state has failed to understand national security, and the court knows better. And it's ironic that that happens in a case where the consequence then is the deprivation of rights. So where the court is deferential, there the result is deprivation of rights. Where the court is activist, the result is also deprivation of rights, which is a sad history of various things in our jurisprudence. So what that then does is that it sort of constitutionalizes the idea that the burden of proving that you're a citizen is upon you. So no Parliament can depart from that now. It's at the level of the Constitution, and that sort of accelerates then the move towards the NRC, and what it's done. This is linked to another sort of broader idea, which is that citizenship actually is often called the right to have rights, which is that once you are a citizen, that is when you get access to certain core or important rights. Under the Indian Constitution, for example, Article 15, the non-discrimination clause, Article 19, free speech, and so on, these are rights available to citizens only. All persons have a right to equal treatment, but more specific rights are only available to citizens. So citizenship is then the right to have rights, because if you don't get that sort of trigger or threshold, you don't have access to a number of rights, which would then imply that any attempts on part of the state to deprive an individual of citizenship should be treated with particular care and should be scrutinized by independent institutions like courts with care, because the result of it is not that you lose any one or two rights, but a whole bouquet of rights that are contingent upon your status. That's what should be the approach. Instead, what we have is the opposite, which is that the Parliament is given almost a clear road, or the executive, when it's in these proceedings, is given a clear road, unencumbered by scrutiny, to decide when to take away citizenship of an individual. So that's an ironic reversal of that basic idea. You see it a lot specifically in the workings of the foreigners' tribunals, which the book deals with. And just to add a legal gloss to the book's arguments, the foreigners' tribunals, they are the tribunals that decide claims or cases where the border police says that you are not a citizen. Then you get taken to the foreigners' tribunal, and then a hearing happens, and then a decision is issued, and that decides you. And then the tribunal makes a recommendation to the government about your status. The procedural rules that govern the workings of these tribunals are non-existent. They can decide their own procedure. They can decide how they take evidence. They are not even required to issue what in law we call a speaking order, which is that you have to give detailed reasons for what you have decided. So not even required to do that. So basically, it's a free for all, effectively, in the tribunals. And of course, you've read those pieces where tribunal members were joking that who took the most number of wickets, and that was a euphemism for who could declare the most number of people non-citizens. Again, going back to the Supreme Court, so a case came to the court in 2019, and the argument was that look at all these procedural lapses, all that, in the foreigners' tribunals, and therefore treat a foreigners' tribunal recommendation as simply an executive order with no further sanctity. So, for instance, if the foreigners' tribunal declares somebody to be a non-citizen, that should not impact that person's exclusion or inclusion from the NRC. Because in Assam you have two processes, the NRC list which was being prepared, and the foreigners' tribunals that are proceeding independently. And what was happening was that if you were declared to be a foreigner by the foreigners' tribunal, it would follow that you would be off the NRC. So the argument was that just treat this as an executive order because they act like the executive, and don't merge it with the NRC process. That should be a separate inquiry. So one shouldn't doom you in the other as well. And the Supreme Court says nothing doing. Actually, we are going to treat this like what they call a quasi-judicial finding, which means that it's somewhere between executive and judicial. And the impact of it is that if you are found to be non-citizen by the foreigners' tribunal, then the result is that you're off the NRC as well. So you see again how the entire attitude here is what is effectively a presumption of non-citizenship. So the idea is that you are presumed to be in the wrong, to be a non-citizen, once the acquisition is made, and once it's made, then every other bit of interpretation supports that, and then you have a tall order to prove otherwise. And that, I think, sort of explains to you all the news articles about people who are found to be non-citizens, the various consequences, and the book of course talks about that. My final point is, and so this ties back into the original Constituent Assembly debates, is of course during the protests against the CAA, one interesting thing that I saw was the predominance of Article 14, the preamble of course, but also Article 14 in the public opposition to the CAA. And then there were many lawyers who, in good faith and correctly, were pointing out that the actual threshold test under Article 14 is a very, very deferential test to the state. So you just have to show that there is an intelligible differentia between the categories that the state has sort of created, and that there is a rational nexus between that differentiation and the state's goal. So very, very deferential test, and it's very hard to actually in court win purely on Article 14. You have to do something more because it's such a differential test. But what I found interesting was that this was almost an attempt to sort of reclaim Article 14 in the universal sense, that it is a broad, overarching principle of fairness and of equality that is, in a sense, almost rescued from the narrow confines of legalistic interpretation. And in the public sphere, it stands for something broader, which is linked back to the Constituent Assembly's overall idea of a more universalistic and equal citizenship that finally found its way into the constitutional text through implication and not in an express way. So I found that aspect of the language of the CAA protests interesting and of relevance to the book's core arguments. So I'll end by thanking Professor Roy again, and thank you for inviting me here. The last time I was here was a few years ago. It was in celebration of a bail order that had been passed, and yesterday, of course, there was another bail order that went the other way. And I just want to maybe end by acknowledging that all the people who are not here with us today but should have been, and hopefully they will be with us again soon. Thank you.